Well, we got tons of arguments still to get to from yesterday's Illinois Supreme Court hearing, including the back and forth between the defendants and the plaintiffs after the court hearing. Let's go ahead and hear from what Illinois Attorney General Kwame Raoul had to tell members of the media yesterday during the kind of post-hearing analysis of sorts. Here's the Attorney General from yesterday responding to a whole host of questions from members of the media.
I think that's a false argument. I mean, what they pled, they're taught in law school to plead the cases, the matters that you want argued. They strategically, perhaps they didn't want to argue in federal court, they strategically, unlike others who have challenged this act, they chose not to plead a Second Amendment case, and so there's no reason for the Supreme Court to go that.
Now, Raoul, he also said that he was confident, especially, with various high-profile mass shootings that have happened, so he laid that out. But he was asked about the difference between those who are grandfathered and those of the general public who aren't grandfathered. Why are they given this kind of special privilege of the Second Amendment when it comes to accessing commonly owned firearms?
There's some people who are... the legislature made the decision to grandfather some, and then to make exceptions for those who are serving in sort of a law enforcement capacity.
So the Attorney General, again, laying out the rationale he believes that allows for some to have them and others to not, and it's about eliminating the proliferation of what he calls assault weapons. But I asked him, well, if it's all about training, then why can't I get the same type of training, pay for it out of pocket? Why can't I get that same type of training that, say, law enforcement can get? And here's the Attorney General's response.
Can I not get the same type of training that law enforcement can get, or security or wardens can get? Can I,
Well, you play a different role, right? It's not just a question of training. You're not in a law enforcement role, I don't think.
Well, and then I asked him about the federal cases.
With regards to the federal cases, we're going to litigate that in federal court, not before microphones.
So you don't want to talk strategy or?
No, but I appreciate the offer.
So Attorney General Kwame Raoul there after the hearing. You can watch the entirety of that 5 minutes on my YouTube channel. Just search Bishop on Air and you'll find that. You can also watch the entirety of the 12 minutes with Attorney Jerry Stocks outside of the Supreme Court in Springfield yesterday, where he talked about, I guess, his initial reaction to how the hearing went, getting peppered with all kinds of questions.
Well, anytime you argue, you never know whether a justice is testing your resolve in a particular principle or contention, or whether they're trying to tell you that you're clueless on that contention. So it's always difficult to predict a panel, and so we wait patiently and hope that the analysis not only considers everything that was argued today, but there's a lot more depth and a lot more detail on the briefs of all the parties.
And I asked him about how this obviously is, a question of equal protections and Second Amendment, but the court's really asking about whether this is a Second Amendment case. Here's Stocks yesterday.
This was about the fundamental individual right under the Second Amendment that could not be diluted by Illinois' version of the Second Amendment, and how that was the beginning point for the analysis. This is a declaratory judgment action. The rigidity which they're seeking to apply to the pleadings would really be a significant break from the general rules of civil procedure and reviewing these things. And the fact of the matter is, the Supreme Court under Rule 366 can embrace a full breadth of issues, and under its own precedent can determine it on any basis found in record, anything argued implicitly, and all of these issues were present in our briefing below and also informed the 5th District's opinion and accuracy. So they're the highest court. So there's what they want to embrace, there's what they may want to avoid, and the reasons for that very well could transcend the four corners of this case.
So he also sets up an example about equal protections, talking about how you can't block one person from voting, but then he simplifies it down to the Second Amendment arguments.
Perhaps its most simplified is the Second Amendment, because it is declared to be an individual right above all other interests. And so anytime you get into some balancing, that fundamental individual right has been declared by our U.S. Supreme Court to elevate above all other interests. So that's whether we're here on equal protection, special legislation, Second Amendment. It is what is at issue in this case. That's at the core. It was at the core of our complaint.
So again, we're hearing from Jerry Stocks. He is the attorney representing Dan Caulkins in the case brought before the Illinois Supreme Court yesterday. He was asked to explain, we have obviously the equal protections, we have the Second Amendment, we have this idea of special legislation. He was asked to explain that aspect of his argument.
Special legislation is passing a law that reposes a benefit, immunity, or privilege to one person similarly situated that's not given to another. Here, the grandfathered are given an immunity from prosecution. They're given the privilege of possession. They're given the right of transfer and sale, or not of sale, but the right of transfer to an heir. Those that do not have an assault weapon as defined don't have those rights. And there's no difference in their training. All it is that one happens to have the gun already. But consider this, is that if they want to justify these classifications on training, how is the grandfather trained any better than the other layperson that wants the gun? Mere possession is not training. That is the bellwether of arbitrary classification. And that is where special legislation should drop this legislation.
So again, Jerry Stocks representing Dan Caulkins in the case heard before the Illinois Supreme Court yesterday. No real indication as to when we're going to see a ruling come out of the Illinois Supreme Court. That could be in the weeks and months ahead. We'll keep you posted on that. And we'll have to talk more about the issue of the conflicts of interest allegations that Stocks brought against the two justices. We'll have to unpack that later. We just don't have time for it right now.